talk to us a little bit about probate and guardianship and some issues that we may encounter with respect to divorce. We have your questions and she's here to answer. So Gina, please introduce yourself.
Hi, good afternoon. I'm Gina Chevalier. I'm a South Florida Estates and Trust attorney, and I handle all aspects of estate planning, probate, and guardianship. My main clients really end up being, people that have made their wealth on their own or that have found themselves in the unfortunate situation of having to deal with either somebody that needs a guardianship, whether it's an incapacitated adult or an adult child, or a situation where somebody has passed away and now there were assets in the name of the deceased person that we need to get transferred over.
Yeah, and Gina, thanks again for coming and for answering some of our questions. And just a brief background, Gina and I, we know each other from a group, and she's actually given a few lectures, which I've attended, and she's just a source of knowledge. So I'm so happy that we get to pick your brain now. So I guess my first question, or our first question, is what are some of the issues that you encounter with respect on the probate side that are kind of related to divorces? So for example, what happens if parties are divorcing, the divorce is not finalized, and one of the parties dies before the case is complete? Like, does that affect your will, your probate, how your estate is going to be divided? I mean, I'm sure there's a lot of questions within those questions, but what typically happens? Just
right. So there's a couple of layers there, and I'll speak to that a little bit. So what happens is that until you have that final judgment of dissolution of marriage, the divorce is not considered final, and the probate court doesn't recognize what's going on in your divorce proceeding, in the sense that it doesn't change your beneficiary either designations. It does not change what you already have in a drafted will or anything of that nature. The spouse still has certain rights, including if the other party that's in the divorce has decided, you know what, this is a nasty divorce, it's been going on for way too long, I'm drafting a will and I'm leaving my spouse out of it. Well, under Florida law, the spouse still has certain rights, one of which is called the elective share rights. So they have to file a petition for a spousal election, or for the spousal to take the spousal elective share, or to make that determination within the first 9 months after the person has passed away. So that, they still have that right if the divorce is not final. So just because you are in divorce proceedings, your legal status with regard to probate does not change. So unless you have drafted a new will, that person will still inherit, based on the terms of whatever your existing will was. And if you do not have an existing will, then the issue there is that it goes by the intestacy law. And the intestacy law is very specific. So if you're married and all of your children are children in common, or neither one of you has children, it goes 100% to the spouse, to the surviving spouse, right?
Wow. So let's say someone just initiated divorce and they do have a will. Do you have any advice or any recommendations you would give them from the onset?
Yes. So at that point, I would sit down with them and then find out, what are your intentions with regard to your current, soon-to-be former spouse? Do you have children together? Are there minor children? Who is going to handle the financial assets that are in your individual name, in the event that you pass away? And some people have health issues. Some people were very concerned during COVID. Other people, just have been diagnosed with something. And they may say, you know what, even though I'm going through this divorce proceeding and I think it's going to happen, I want to protect myself and my children, and go ahead and draft a new will and a new document. Because in many cases, people don't want their ex-spouse controlling all of their assets in the event of their death, to take over, the administration of what is given to their children when. So that's one of the issues. The other thing is they may not want that person to serve as personal representative. But you also have the other side of the spectrum where some people are just like, no, I absolutely trust, that's the parent of my children. They are going to make sure that, my children's needs are met. I have no problem with that. So it really depends. It's a case by case situation, and it depends on, the person's relationship with, the soon to be former spouse, and what their wishes are at the time, because sometimes those don't change. And oftentimes what happens is people are so consumed with dealing with their divorce that they don't think about the what ifs that happen. What if I'm driving, get into a car accident? What happens in that situation? So those are definitely questions to discuss, but it really depends on a person's priorities at the time.
Of course, and every case is different, so it's a case by case basis, like you
Right.
mentioned. So now let's go into a little bit of post divorce. So once you're divorced, is there any recommendations you should make at that point? Are there
Yes.
certain documents you should get in order or correct or modify? What do you recommend?
Absolutely. So I always tell people that, once you've gotten divorced, an important thing is take a look at your estate planning documents, take a look at your beneficiary designations on your accounts, your beneficiary designations on any life insurance policies, retirement accounts, basically everything. Take a full inventory and make sure that those documents reflect what your wishes are going forward. And if you've gotten a divorce and you still want your spouse or your former spouse to be in control of certain things, if you really don't want to make any changes to your will, you want that person to continue to be in the role that they were in, I always recommend do what's called a codicil to your will, indicating that your divorce was final on X and X date. On as of this date, I want no further changes to my will, and I am simply publishing this to republish the will that I have, stating that it is in full force and effect. Because there is case law as to presumptions as to what occurs if you've named a former spouse in your will. The alternative, which is, I would say, probably about 70% of the time, people don't want their former spouse in whatever same role they had them in before. They don't want to leave them anything. They don't want them in charge of their estate. They don't want them in charge of distribution. They don't want them as the trustee of their trust. They may not even want them as the guardian for their children, but we'll get to that one. That's another thing. There's certain things you can and can't do. But with regard to your assets, your individual assets, you can leave them to whoever you want, as long as you don't have minor children. If you have minor children, there's a rule in Florida, a law in Florida, that you cannot disinherit a minor child. So you do need to leave something for those minor children. And you may decide, okay, they're minors, or maybe I don't want them getting it all at 18. So instead of just changing my beneficiary designations to my kids, or a mistake that many people do, I'll just leave it all to my sibling, my sister, my brother, and they know what I want, and they'll make sure that this is taken care of for my child. But that person may have a spouse, that person may end up in divorce, that person may end up in a car accident, and then where are your kids? They're kind of out of the picture. So most of the times, I strongly discourage that, but that in very few instances is something that can work. What you can do instead is you create a trust. It can be a testamentary trust in your will, which would still have to go through probate to then fund the trust, or you can create a standalone revocable living trust in which you state, okay, the assets are going to be held for my children. This is going to be the trustee for the kids, which means they handle all the finances, and the kids will get it under these circumstances. Maybe they can provide for their health, for their other education, maintenance and support up until a certain age. And then they start maybe getting little chunks after a certain age, or you make sure the college is paid for. You can basically do anything in there. But one of the things that people do very often is that they say the former spouse is not to have any financial control or to receive any direct payment, even if it is for the maintenance of one of my children, through this trust document. So if the kids need something, pay for it directly. I don't want it to go to my former spouse. So, you have that flexibility in there.
Okay, so it's okay if you do either a trust or some sort of language including, hey, I don't want my spouse to be any part of or receiving any part of this money. It's going directly to the kids. That's legal. That's allowable by Florida law.
Yes, you have to do it in either a will or a trust. Okay, you can't just leave a handwritten note because Florida is not, uh, and people do that. So it's not. We joke, but it happens. You can't just leave a handwritten note and say, I want my money to be handled by my neighbor, or my mother, or whatever it may be. You have to state, either in a will with the proper formalities or in a trust with the proper formalities, what you want to happen. And even if you don't get around to retitling your assets into the name of your trust, it can still go through the probate court, through your last will and testament, and into your trust. And in there, you specify, who gets it, when they get it, and how they manage it. So yes, absolutely. There are many terms that can be put into a trust. It's not just about what happens, who gets what when, but how they get it and who is responsible for making that decision. Sometimes we put in alcohol and drug use provisions because somebody's concerned about that, or maybe we have a mental health provision because somebody's concerned about someone's mental health. There's so many things that we can put into a trust document that really kind of help you reach out and make sure that your kids are taken care of after you're gone.
So if there's someone that say they either during a divorce or it's post divorce and they have children at the time, minor children, and they want to either leave in a trust or leave in a will, something for their kids to make sure that they're taken care of in the event that something crazy happens and they were diagnosed, or like some, for just as a precaution. Is that something that you can help with?
Absolutely, absolutely. We can definitely do that. And, usually if it's during the pendency of a divorce, I usually tell people, maybe we just want to do a last will and testament right now, because we don't want to start drafting a trust and then having to disclose that, because you have disclosure requirements if you're not retitling assets. You don't want to retitle assets during a divorce, but you can draft a last will and testament, and you can update beneficiary designations, as long as you haven't gotten to the point of you're in settlement talks and you've already spoken about, okay, this is what we're doing with regards to beneficiaries, et cetera. So you always have to keep in mind that communication with the attorney that's handling estate planning for somebody that's in the midst of divorce, it needs to be, they need to be fully disclosing certain aspects of what's happening in the family law case so that we can be aware and properly advise them.
So when you're saying that you need to properly disclose certain information, if you're in the middle of divorce proceedings and let's say my client wants to have everything handled at that point to make sure that, if that person passes away during the pendency of litigation, that the kids and, whoever her intentions, whatever her intentions are met, is that something that, what is it exactly that you have to disclose?
So if you retitle an asset in the middle of a family law proceeding and you guys are still in the discovery phase, they may start questioning, why are you retitling all of these assets? You can just tell them, I'm drafting a revocable living trust, and usually it ends there. But if you have a very litigious situation, you want to proceed a little more cautiously there, because you don't want to open up now, okay, well, we want all this other discovery. They may not want to have to provide their trust document, to their soon-to-be former spouse.
Yeah, that makes sense. And
Right.
the last thing you want to do is create more work in a divorce, especially. And it's usually the case that it's the highly litigated ones are the ones that kind of like, if you're changing something, then they really want to know why. And they think people have bad intentions, and sometimes they do, sometimes they don't. So I guess the bottom line is it makes things a little smoother if you do a will at that point in the stage of litigation, as opposed to creating any type of trust. Or
yes. If it's your first time creating a revocable living trust, I would say yes. If you have an existing revocable living trust and we're either amending it or restating it or doing something of that sort, then no, we can proceed. We can proceed with that, as long as your trust isn't subject to any part of that litigation. Usually, a revocable living trust is the same as if it's you during your life. So what ends up happening is, the other party has the disclosure information. So if it's already titled in your trust, it doesn't matter. You're changing the terms of your trust. You're changing it. It's still your asset.
So you don't, okay, and now I kind of clicked for me now. If you already have a trust and you're changing it during litigation, you don't need to disclose anything because they already know that you have a trust. It's what you have to disclose is the fact that you have a trust, not what's necessarily inside of the trust.
Well, no. So let's say, for example, your normal discovery, they're asking you for your bank accounts, your statements, your financial accounts, all of that. If I was getting divorced, my accounts are already titled in the name of my trust, I would give them that. They see that the account is titled in the name of my trust. It's a revocable living trust. The same as if it's me during my life, reports under my own social security number. So that's no issue. It's my asset. Okay. Now, if the asset is titled in my individual name and then I'm creating a new trust at that point and I'm changing the title of the account, because what happens when you change title to your account to now title it in the name of your trust, most banking institutions require you to get a new bank account. They want, because now it's a name change and they have like these internal policies. So most institutions will ask you to create a new bank account. So now you have to have, all of this new discovery. So you don't want to put yourself necessarily in that position.
Right, and then of course, in any divorce, if there's a bank account and you're associated with it, you have to disclose that too. So, yeah, okay, cool. Well, Gina, thank you so much. I'm gonna have all of your information in the comment section. Is there a specific way that you would like people to reach out to you? Is a phone, email? Is there a method that you prefer?
Sure, any of the above. Actually, you can email us if you want a consultation or you have some questions. The email to address is clerk, CLERK, at Chevalier Law, CHEV as in victory, ALLIERLAW.com. And we're happy to give them any information that they need, set them up for a consultation if they'd like, or they can reach us at 305-974-1490.
Wonderful. I'll include all of that in the comment section, and I'll also include a link to your YouTube because you have a YouTube channel and it goes over a lot of frequently asked questions. And I know that that's extremely helpful for a lot of people, even for lawyers like myself. So Gina, thank you so much. And we can't wait to have you back to answer some more questions.
Great. My pleasure, Anna. Always love talking to you.
Okay.
Have a great one.
You too.
Take care. Bye-bye.